few seconds. Today is 164th Friday group meeting. Today topic is the art of legal drafting. The speaker is our beloved senior advocate Dama Seshadri Naidu, very prominent personality. Everywhere you have a very good name, sir. You always have a smiling face. Friend of mine told very confidentially, secretly, then I confirm. If you ask from any dictionary, any word, he will tell you the meaning. Oh, that's made a lot of journey. Finally, this thing, judge of Bombay High Court, Kerala, then Bombay, then took voluntary retirement and joined in the bar. He's doing excellently. So I request Verma will say a few words about sir. Please take this. Keep it in. Yes, stand better. Take first, beginning.
Blessings. Past is history, future is a mystery, but the present is a gift of God, and thus rightly named so. Today, from a Friday group, the knowledge of hub, which we would like to use this precious time to welcome and honor our renowned figure who greatly influenced our judiciary, Honorable Justice Dama Seshadri Naidu. Born on January 19, 1962 to late Shri D. Narayan Swami Naidu and late Srimati Lakshmana at Ganganganta, a hamlet away from Tirupati, the holy pilgrim town, Chittor district, Andhra Pradesh. Did his graduation from Andhra University, Visakhapatnam. Later he obtained law degree from Sri Venkateshwar University, Tirupati. Thereafter he got enrolled as a member on the rolls of the Bar Council of Andhra Pradesh in March 1997. To gain the trial experience, initially he established his practice in Tirupati and practiced in both branches of civil and criminal. Later, having shifted practice in early 2000 to Hyderabad, he started his practice in High Court of Andhra Pradesh as well as the civil and criminal court in the city. He got himself associated with a few law colleges and state judicial academies besides National Judicial Academy as a guest of faculty. He taught various subjects and continues to teach. He authored a few law books such as The Law of Stamp Duty, Registration in Andhra Pradesh and the Andhra Pradesh Educational Code. In 2017, along with Justice Chalmeshwar, Mr. Naidu revised MP Jain 2-volume Constitutional Law of India. In 2022, along with Mr. Namit Saxena, he co-revised Mullah's Abridged Code of Civil Procedure. Mr. Naidu has fascination for literature, Telugu and English. He has the enduring habit of listening the radio and an ear for music. He is also fascinated by neuroplasticity, the developments in that field of science he closely follows. Mr. Dama Seshadri Naidu was elevated as additional judge of High Court of Andhra Pradesh on 21st September 2013. In June 2014, his lordship was transferred to High Court of Kerala. On confirmation as a permanent judge, he served Kerala High Court about 5 years. In March 2019, Justice Naidu was transferred to Bombay High Court. In August 2021, Justice Naidu resigned and became Advocate Naidu once again.
Senior advocate.
Senior advocate. Yes, I'm sorry.
Yeah.
In May 2022, the Honorable Justice designated Mr. G.Seshagiri Naidu as a senior advocate and still continuing keep blessing over here. Thank you.
Thank you, Geeta. So nice of you. So a small introduction, we will go one by one. So immediately, Sheshagiri, you can introduce yourself, please.
I'm Geeta Verma.
Yes, sir.
Quickly, please.
Ajit Kulsresh.
Vandana Mandal.
Rahul Sharma. Amit Pratap Singh.
So Yogesh Sharma.
Thank you.
Giriraj Singh Rawal.
Here also, this side also. Please, come in. Oh, no, sorry.
Patient Sushi.
Good.
Amit Pratap Singh Yadav.
Yes, sir.
Still Kumar. Dev Singh.
Yeah. Now you, please.
Thank you very much And my pranams to all of you, having spared the evening for me. And my thanks to my friend G.Seshagiri for introducing me into this elite group. And I know Fridays are quite enjoyable days. Now, I don't want to be a damn squib on your enjoyment. I would like to be short as possible. And especially the young brothers and sisters of the bar, I look forward to more of an interaction rather than my telling something in an abstract way. That's what I would like to propose. I know, though I could see a handful of faces online, many are there. It's become very popular. I was told that Friday group has become very popular, and that's why I would like to reach to whatever extent, especially given my experience on the other side, how, a judge turned advocate is like, as my brother could vouchsafe, like a mermaid, half fish, half human. So I am half judge and half advocate, even now as an advocate. So sometimes where there is criticism of judge, one part of it feels bad. Criticism of advocate, one part of it feels bad. But what I would like to share today is my experience as a judge when it comes to pleadings. So that you would see, not all judges would think alike. Every judge will have his own idiosyncrasies, but perhaps there is a common golden thread passing through all these things. In that sense, I would like to say what my experience was when handling the cases, or the pleadings. And once I run through, say, for 20 minutes or whatever, I would like to interact, because it's something like everybody knows and not many people know. There is a contradiction, sort of an oxymoron. That because ever since we have become lawyers, we have been pleading. And we take it for granted. There is a saying, what is obvious is apt to be missed. As I said at the very beginning, I don't want to sound what you call pedantic or stuffy in my view. I rather prefer as a freelancing discussion or freewheeling discussion. So if at all I ask any young member of the bar any question, don't feel embarrassed, nor am I trying to be overbearing on you. And also, our legal profession, either judges or the advocates in that sense, suffer from one limitation that is called binary thinking. We always think, we hold ourselves back that for a question, answer should be either yes or no. Please don't think that way. There could be answers with many shades. There's no such absolute dichotomy or a watertight division for a question to be right or wrong. It can be either way. Young advocates especially, there is a series called The Crown Court on YouTube. About 300 episodes are there in that one. You kindly watch them. You greatly gain the way the trial courts function and also the way advocacy is practiced. Though we are not in trial court, but still you can see valuable inputs when it comes to the practice of law. There, once, an expert was cross-examined. Then the advocate puts a question to her, and she wanted to explain an answer. He shoots back saying, please, Madam Expert, tell me yes or no. Quite usual, if you have had trial court experience, you could have seen that one. The advocate will say, please tell me yes or no, nothing else. Then she says, yes, young man, I started my career always believing for every question there is either an yes or no. Now with all my experience, I have realized every yes has many shades and every no has many shades. That's why there is no such dichotomy. That's why feel free. I said at the beginning, I would like to make it truly reflecting the spirit of Friday. And may I do some sort of an experiment with all of you to underline the importance of pleadings. Those who are willing, please join. Not willing, please ignore me. Touch your chin. As many as possible, please touch your chin. Then, touch your lips. Touch your nose. Touch your eyes. Touch your eyebrows. Look at me, please. All of you. Touch your forehead. Please Yes, that's it. What I've said is, touch your forehead, but I showed my head. So almost all of us, barring one or two, have touched here. What I say is, people are guided by visual cues than by what's been said. Right? When you are articulating as an advocate before the judge, you have the advantage of this gesticulation, this physical expression more than the words. You can cover any lapse, but when your brief reaches the judge, you don't have this advantage. That's why the importance of pleadings. Second thing is, suppose you have an important case and you have got the best of the brains to do that one. Right. You feel that let me not take a chance, let me have a very famous, whichever way famous, advocate, a senior counsel to plead on to argue on my behalf. All right. Usually on a Monday and a Friday, the judges come after thoroughly reading the briefs. While reading the brief, they didn't know it's going to be argued by so-and-so, so-and-so. First thing. And second thing, usually the first impression, they form an opinion, and it takes a lot of effort for us to weed them away or take them away from that opinion. So what happens is this. Most of the times, the case fate is determined based on what you have pleaded. Anybody else trying to do something later is of not much consequence in my view. And let me tell you, when I resumed my practice exactly 1 year ago, I began last year, October, that was November, I began. I met one former Chief Justice of India. Because of my earlier avatar, I had some acquaintance with that former Chief Justice of India, who retired a few years ago, so that there won't be any guessing. Right. I asked him, you had been on the bench for about 21 years, sir, or 22 years. And always we have a feeling that somehow in Supreme Court, the senior counsel get away and the juniors suffer. Whatever it is, now I have resumed my innings. I'm not that much experienced, by then I was not designated, whatever. Please tell me, when you read a brief, what impresses you? Or, to be successful, what I should do? I've asked him. He said, Mr. Naidu, either you win or you lose in the first 2 pages of your SLP. That's what he has said. Right? And with my earlier exposure on the other side, let me tell you, you could have seen an advocate practicing along with you, here, Hyderabad, High Court, whatever, and you may have a particular impression, he is reasonable, he is logical, he is liberal, he is good in a sense. He gets onto the bench. And you feel this man has completely changed. And he's become so rigid. He can't understand even small things, having practiced it that much. There is always this friction. I tell you what happens. This is one technique some experts have engaged or employed. See, we all as advocates think ex post. And the judges think ex ante. If you read any good book on legal analysis, you will see that explanation there. You know what happens, ex post thinking is this. Look, there is a problem. My client suffered. Please provide him a remedy. I stop there. Because you buy just, I buy remedium. I have a problem. You provide me the remedy. This is our contention. And the judge thinks ex ante, especially in the constitutional courts. Ex ante thinking is, you may have a problem. I have to provide the solution. But still, I am worried about its impact on future. That presidential problem. In day-to-day example, let me take one commonsensical issue. Somebody hijacks a flight, an aeroplane. It has 450 people on it. and they send a demand to the government, whichever is the government, that, look, you have arrested one person and you have kept him without any trial, whatever. If you release him, we'll release 450 people. Otherwise, we'll blow it away. So, commonsensically thinking, it is one life versus 450 lives. Right? One life versus 450 lives. Anybody will say, look, let him be released. We again will have a chance of catching hold of him. But these 450 people, once they are lost forever. So let them have it. So that was the initial ex post thinking. So they were releasing and they were hijacks. Then all the nations have come together and they have decided, say no to it. Because their crime pays. Say no to it. Last 30 years, across the globe, all countries have signed and they have said that no. Have you ever heard about these hijacks in 30 years? No. This is ex ante thing. So most of the times the decisions are ex ante by the court, and we feel disappointed because of that. Now, why should we have some attention or focus on the pleadings? You know, when young advocates were arguing before me, they would try to impress. Naturally, even I try here to impress a judge to get an order. Nothing wrong in it. And in that process, they get themselves tied up in the knots of tension and everything. I used to tell them, look, everybody loves stories. Advocacy is nothing but telling stories. So tell me an interesting story, carry the day. And when it comes to pleadings also, it is human drama we are talking about. Every case involves human drama. And you take any author who writes, he would be writing, say, 10 books in his life. If you're an Agatha Christie, you must be writing about 50 books, whatever. But imagine in our lifetime as an advocate, how many pages we draft. Perhaps if there is any biggest writer, most prolific writer on earth, it is the lawyer. Then why not we hone our skills? The skill of telling stories. I tell you what the skill is. Because I said advocacy is nothing but storytelling. If you permit, I'll tell a story.
Yes, sir.
Right. See, once a king went hunting. And he came back to the palace. He was really famishing and hungry. So he went into the dining hall, asked the royal chef to serve him. He served him, you know, eggplant or brinjal curry? He served it. King was very, very hungry, ravenous. He enjoyed it. Then he praised this man, the royal chef, and gave him some part of jewel he has given him. So this chef took a cue from it. Every day he started serving only that one. Every day he started serving that one. Then what happened? At the time when he was praising, the royal jester, we call Vidushak in some languages, I don't know in other cases what you call, royal jester, he said, Your Royal Highness, it's right, brinjal is the tastiest curry on earth. Even God has rewarded it with a crown on its head. Right? That man wanted to please that king so that he would also get his whatever farman or gift. So king gave him something. Down the line, 1 month, chef doesn't change it. Then king became angry. Then he started scolding that and saying that what horrible curry this is, don't ever serve it on to me, etc. Then everybody was looking at this royal jester. What he is going to say? Last time he said there was a crown. And he said, yes, your Royal Highness, there's the worst of the vegetables. That's why God has put a chisel on its head. My friends, this is advocacy. Turning even the adverse circumstances to our advantage. When you are on your feet, you may not get much time and not much thought process. But when you are at the desk writing, you will have every time. So, our strength, our weakness is everything that is pleadings. This is how I would like to underline the importance of pleadings. And when I've started talking to you, up to now could be perhaps 10 minutes, whatever, have I used any difficult word? I don't think. Quite conversational I am. Then in our pleadings, why can't we be talking from our pages? Please talk to the judges from the pages. When they read, they should hear your voice, not an extract from a textbook. My request is, even when I started my career as a judge, you could see first 2 year judgments, I was very strongly trying to ape Krishna Iyer. But there can be only one Krishna Iyer. Not every Seshadri can become a Krishna Iyer. Then I realized the futility. I have come into my own way of using simple words. You know, when you take a cell phone, can I put it?
Yeah.
You take a cell phone, keep it at that end, draw a cable from this end to that end, long cable. It takes a lot of time to get charged because the loss of electricity because of the distance factor. Put a short cable, it reaches and charges very fast. So are the pleadings. The longer the pleadings, the slower it gets into the judge's mind. And more so in India, judges have been overworking. You know the international standards? UN recommendation is 50 judges for 10 lakh people. And most of the advanced countries have 80 to 120 judges. And India has 18 judges for 10 lakh people. And in American Supreme Court, 9 judges sit together. They decide on average 70 to 80 cases a year. And each judge may be writing the entire year 5 to 10 judgments. Whereas a Supreme Court judge or a High Court judge here writes every day 10 judgments. So what they look at is succinctness, shortness, precision and clarity. They don't have the time to read Charles Dickens novels or that style of pleadings. So maybe earlier when a letter is posted to us and we expect that our mother, father, wife, whoever, our husband, as we are in Delhi, will post a letter every week. It will take us 4 days to reach, and we were never excited and we were never impatient for 4 days because we knew it would take 4 days. Now, send a mail. I am sitting across. I haven't received. What happened? No, it must have been gone into this junk, and please send it again. See the attention span. And somebody has told me our attention span has come down to, on an average, to 30 seconds. So, you have to impress the judges with the pleadings in the shortest time possible. For that purpose, what I've realized, not only me, the international linguistics, professors on the linguistics, they have done a lot of research, including neuroscience, how the brain receives information. Right. There is one beautiful guy called Steven Pinker. Steven Pinker, he has written many books on neuroscience, how words impact our brain, how reading impacts our brain. Any of you can read, including Blank Slate. Right. See, what's been said is, make it a rule to keep your sentences not more than 25 to 35 words. 35 is the maximum length of a sentence. Or to have a thumb rule, please see that it will not exceed 2 printed lines. When you are compelled to use a long sentence, invariably follow that with a short sentence. This is called staccato style. So that there is some novelty, some avoiding of monotonity. So the lesson I have learned on the bench is that I always loved short sentences. and each sentence should contain only one idea. This is, my friends, very, very vital. Technically speaking, you can write one sentence endlessly into an eternity. It's grammatically possible. There's no need to end a sentence in 10 lakh pages also. It can ramble on. You can have conjunctions, then you can have adverbials, you will have complexity. So it goes on endlessly. That's why never ever take pride in writing long sentences, because the comprehension is the victim of that one. 2 lines, not exceeding, or 1.5 lines to be ideal. Then let each sentence carry only one idea. Another example. You know what attracts a reader from a page? Not what's been written, but the blank. The visual attraction, I can put it in a different way. Don't ever write one entire page with one single paragraph. Break them into 2-3 paragraphs in each page. Then comes, when it comes to the paragraph, the first sentence of the paragraph must contain the idea. The rest of the paragraph must expand that idea. Even when a judge reads first sentence of each paragraph, by the time he reaches the end of your brief, he would be carrying the gist of it. And you know, with all your experience, you would be getting it. There's one more thing. As I've told you about this ex ante thinking, we plead based on the injustice our client suffered, or we believe at least the injustice that's been meted out to him. But the judge will have a macro picture or a larger picture about the society, etc. So he thinks, anyway, lower high court, another constitutional court, has decided against him or against her. Why should I interfere? So the first page, see, with great respect, I should tell you, it's audacity on my part to tell all of you how to plead in SLP. My experience here is only 1 year or less than 1 year. You have got more experience. So my apologies to that extent. But it's my opinion I am conveying. You may reject it if it doesn't, because sometimes my ideas may be hairy-fairy, not born out of practice or experience. But having read a few books on how the judges have thought, and having seen that, not much of a difference between a High Court and Supreme Court when it comes to pleadings, you know that one. So there I felt that way, that's why I'm telling. See, I was told subject to correction. Some of you may have seen Nani Palkiwala practicing. People say, again with great respect, quoting Anji Arjuna in his books, said, Palkiwala has always presented in his arguments the doomsday picture. That means, look, if you don't grant the relief, the whole society is in danger. Even you are in danger. Because democracy is going to come to an end. This is doomsday picture. So, because it goes online, I don't know whether I could tell or not, but what every advocate should be doing is prejudice the court's mind in your favor. Look, it's not my problem alone. It's the problem of the world at large. And this is the example where you can interfere. If not, the problem remains at large, many more people will suffer. Once, I have asked a Supreme Court judge, sir, whatever you say is the law. You can do whatever. We have to write justification, then cite all decisions, and there will be any number of conflicting judgments, and we have to reconcile all of them. It's a big task for a High Court judge, not for a Supreme Court judge. He said, that's entirely wrong, Seshadri, because at least you write with a view that there is somebody else to correct it. Right? Whereas, we have always had this mortal fear that we may be making a mistake. And it becomes, irreversible. And lives may hang on it. That's why Supreme Court judges consciously feel held back before giving a judgment. because it has wider ramifications with a chance of a correction. Whereas others will have the luxury of somebody else looking at it. So what we need to do is prejudice the mind to your favor and also present a larger picture. It's not an isolated case, it's not an individual cause I've been pleading. This is what, at least in some quarters, you realize when it comes to the power of pleadings. Then I have noticed, because I've had my notes and everything, I'm not looking at it for this reason. I was told that it could be 45 minutes. I would like to spend at least 15 to 20 minutes on questions and answers so that young lawyers could grill me on that one. Because 8 years I was asking questions, sometimes absurd questions. Now you have the time to take revenge. Put all sorts of questions to me when it comes to pleadings and your doubts. Don't ever feel embarrassed that this may be a ridiculous doubt. And always, when I was teaching in judicial academies, I was teaching judicial officers rather, and a High Court judge or a Supreme Court teachers, they don't ask any questions. Because otherwise, why should we poke his anger, whatever. Then I used to carry a pocket full of chocolates. I used to tell them, please ask the most absurd question, I'll give a chocolate. Because the whole growth comes out of absurd thinking. Right? Safe thinking leads us nowhere. Safe thinking leads us nowhere. That's why, young friends, ask me all absurd questions.
Today also we'll get that chocolate.
But the problem is, I don't think there's a canteen here to carry that one. Right, when it comes to that one. So, let me tell you, when it comes to these pleadings, we have had one problem that's called writer's block. A client comes to you, he entrusts a matter to you, you need to plead it. You feel it's quite a complicated case or quite an important case, or the client is very potential, so that you will get more briefs. Me also included. I am not getting out any moral high horse. So we would like to spend more time on it, and that spending more time never arrives. Whenever I try to write a great judgment, spending time, I simply forgot the facts and I have to write very briefly. That's why there is one law professor called Betty Sue Flower. Right? Betty Sue Flower. She wrote an article. You can Google it. By her name, you can Google, you will get that article. It's 1.5 page article. She has devised a method called MACJ. You know what's the method of MACJ for drafting techniques? If you are drafting a very complicated case, etc., as an AOR, as the pleading advocate, she teaches you this MACJ technique. That is, you know what happens? M stands for madman.
Madman.
Yeah, or madwoman, either way. Right? A stands for architect. C stands for carpenter. And J stands for the judge or the critic. You can say either way. Judge is always critic. He picks holes in our arguments, hasn't he? Right? So, what he says is that once a client comes to you and he briefs you, or once you read the file, you have got jumble of facts in your mind because fresh. So, Betty Sue Flower compares drafting to building of a house. So, imagine that you are building a house complete of wood, a wooden cabin rather. Right? So, you need a lot of wood to build that cabin or a house. So, what you have to do is, environmental apologies apart, give an axe to a madman. Ask him to go into a forest and let him fell all the trees that are there available, so that you will have a lot of wood, timber. So a madman doesn't have a discretion. He doesn't have a plan, he doesn't have a logic. He goes on felling trees. Then who comes? The architect comes, MACJ. What the architect does, the architect picks up what is useful for the door, what is useful for the window, what is useful for the roof, whatever. He picks up and keeps them apart. Then comes the carpenter. He makes them into a shape. So, house is ready. Then the critic comes, the judge. He says, no, on the eastern side window means lot of ventilation. Put it on the western side because it will be dark, blah, blah, blah. So the critique will be the last. Right? when it comes to writing, when you are dictating your stenographer or when you are typing the pleadings, whichever way you want, assume the role of a madman. Don't think of the logic. Don't think of the sequence. Don't think of the grammar. Like a madman, blurt out everything that comes onto the page. Then pick up whatever is useful from that mass of information. With practice, you will be doing it faster though it appears repetitive. Thereafterwards, have a structure. Finally, put your style or stamp on that one. So, the lesson that I learned on the bench is, there is no good writing. There is only good rewriting. Right?
Yes.
And have you heard about the concept called the curse of knowledge?
No, sir.
I'll tell you, the curse of knowledge. Most of the times young lawyers, they argue before the court. Not here. I've seen that in high court, in trial courts. Sometimes judges don't read the files before coming to the bench. But the curse of knowledge is, to put it in a simpler way, you live in a particular place in Delhi. I wanted to come to you to talk. So I call you and ask, look, I would like to come to your house, which way I should come? And you will say, come by this road, take left turn, take right turn, take this turn, come to that second house, blah, blah. I follow the same thing. I lose my track. I couldn't reach you. Again, I call you. You said, look, you are there at so-and-so place. There is a board called so-and-so. Then again, take this turn, that turn. I struggle. Then you think, this man worked as a judge. He must have decided many fates. He couldn't find a simple address, though I've been giving all the... Right? This is curse of knowledge, because you know how to reach your house, because everything is three-dimensional. Google map is inside your mind, GPS. But for me, there's no such facility. So I struggle. But you impliedly or subconsciously impute your knowledge to me. As you know, you also expect I know. And lawyers, young lawyers especially, they literally live with the file ever since the client came to him, up to the time of his pleading and arguing. And he feels judge also equally knows things, so he begins in the middle. Then I always used to tell them, how do you tell a story? Long, long, long ago. So begin that way. Right? So this is curse of knowledge. So when it comes to pleadings, begin at the beginning. First, introduce the characters. Apart from synopsis I'm talking about, introduce the characters. Then explain their standing. Thereafterwards, follow a sequence when it comes to the events, etc., etc. There is a beautiful book unconnected with us called Checklist Manifesto. Have you heard about it? Checklist Manifesto by Atul Gawande. This Atul Gawande of Indian origin is an American doctor. When he was 22, he was the presidential advisor to Bill Clinton on policy, health policies. Later he decided he'd better practice his medicine rather than in politics. So he full-time became a doctor. Anything to be said?
No, sir.
Right.
First one.
Became a doctor. Then he served in Iraq war as a surgeon, saving thousands of lives of the American soldiers. Then he wrote a book with his experience called the Checklist Manifesto. It's international bestseller. Later, he has also written a few more books. But why I'm telling about Checklist Manifesto is, in that book you can see, every year 100,000 patients die in American hospitals merely because of post-operational complications arising out of only one thing. That is, the surgeon forgets to sanitize his hands before operating. That's why I said at the very beginning, what is obvious is apt to be missed. When you are dictating or when you are drafting, an idea comes. So you are in the middle of another sentence. Then by the time you finish it, this idea goes. Some other idea comes. But your mind always feels you have already written that one. So most of the times when judge says, Mr. Counsel, have you pleaded that? and you are absolutely sure that you have pleaded, you desperately look at it, it won't be there. So what I did, maybe I'm self-glorifying, I shouldn't say that one. As a judge, what I did was, when I was writing my judgments, I always used to maintain a checklist. Checklist means point 1, let's take pleadings. Point 1, who are the parties? Point 2, what is their locus? Point 3, any infirmity they suffer like minority, etc. Point 4, who are the defendants, etc. Then point 5, is there any maintainability issue for this one? Point 6, what is the chronology of events? Point 7, which law applies to it? Point 8, which case law is there? Point 9, whichever your wisdom. So what I feel is, our mind is quite treacherous. It's a storehouse of much of information which may not be required for our purpose immediate. So having a signpost in the name of checklist is always profitable. Imagine a doctor, 100,000 deaths a year because he forgot to sanitize his hands. And when it comes to the final court, we don't plead it. We forget genuinely and bona fide, and then we don't get a chance to remedy ourselves. See the fatality or the consequences. So that's why we'd better adopt a method that will be really good. Then, though I have summarized, I could as well WhatsApp that to you, a few points with regard to all the drafting I've gathered from a few books and I've summarized, especially which are useful, and how to frame issues, how you plead, right? Then how the facts are to be introduced, how quotations have to be put. For example, always remember, nobody reads quotations. When you are reading pleadings from any file, we read what you have pleaded rather than what's been quoted there. So invariably you want to impress on the court that this is the way the court has earlier decided. In your paragraph, you introduce what's been there in the extracted portion. Even that's missed, still your paragraph refers to it. So integrate that into your main pleadings rather than leaving it for somebody else to read. Hard-pressed, time-starved, nobody is going to read that elaborately. This is another aspect we may need to take care of. All those about 20 principles I have just listed out, and they could be looked at. Now, since I have felt that at least I should have 15 to 20 minutes for my question and answer, rather your question and my answer, could anybody, fire away all the questions possible at me? Otherwise, I'll make you suffer with all my reading of whatever I prepared. So which one you choose, you decide. Infliction of pain of reading or the pleasure of questioning and putting me on the mat.
I have a question.
Indeed, welcome it. Yes.
Sometimes what happens is some of the documents, like for example a reply by the opposite side or something, which actually goes against us, and we don't want it to be placed before the court directly, or like to be there on the face of it.
Yes.
But we still want to mention in the list of dates, this is what has happened.
Yes.
But we don't want to enact that document.
Yes.
Can that be very tactfully, and would that be unfair not to enact that
Yes.
document? Because if the notice is ever issued, it would be that the other side will place that document and it might show this unfair play by us. So what can be done?
Well, there is a concept called, or an expression for that matter called, taking away the sting. Right? What's meant by taking away the sting is, suppose you have pleaded something and you have suppressed something. What you have suppressed may be innocuous or something troublesome but not really fatal. And the other side pounces on you and projects that in 70 mm. So you suffer because he has brought it to the court's notice for the first time. You know, courts essentially operate on the trust it has on the counsel. The moment it feels for whatever reason you have not done your job by projecting that for court's consideration, you lose the court sympathy. What's been said is, taking away sting means introduce that and justify that. So you're taking away. The moment your opponent points it out, court feels relaxed. Already he has said it, I have said, he has given reason for that one. Tell the unpleasant thing and give a spin to it. You know, spin doctor, the expression in English, spin doctor. you're a politician, you don't know how to articulate, you'll have somebody called spokesperson. He knows how to put in the most adverse thing into the most favorable light. So that's why don't ever give the opponent to attack you. Something unpleasant, plead that one and give your justification. Convinced or not convinced, at least you will not be accused of that you are suppressed. Yes.
Yeah. Any question, please, further?
I have a question.
Indeed.
Yes. Suppose we are presenting our case before the court and we know that we are on a weaker section and I may lose by so predicting anything before the court would be I would be the sufferer, but still I feel my client should get the relief, some kind of relief, at least some kind of relief because he is a poor person or whatever. So what's in that scenario?
Yes. Good question. Let me tell you. Have you heard about a gentleman called David Panic? David Panic is an English scholar, an attorney, a Queen's Counsel, and he wrote 2 books. One is The Judge. The other one is Advocate. You please read his book Advocate. What he says in that one is, your duty is to plead, not to judge. When a client comes to you, never ever tell him the outcome or predict the outcome. Right? Predict the outcome. You know how sometimes it's their problem. The client is very, clever. He knows how to. There is an anecdote when it comes to my place called Tirupati. When I was practicing, an advocate who once practiced was a legendary person there. They say, he was not there when I began my practice. They say one day a client went to him and he narrated the facts. Advocate, senior counsel, he was impressed. He said, you have got a wonderful case, we are going to win. And also he said, it's never been my practice to assure a client about this one, but the case is so strong, be assured, get the file, I'll file it and you will get the relief. But that man was not that much impressed or he felt rejected. No sir, I don't want to press on. Then he couldn't understand. The counsel said, I have given you such an assurance, how come you still are not encouraged? He said, what I said was other side's case. What I said to your question is this. See, our duty is to plead and leave the rest to the judge. If we focus on the result, or we are determined, even in the best of the senses, that our client should get justice, it's not in our hands. We are not going to give. And by focusing on the result, you become tensed and you can't plead properly, you can't argue properly because you have been emotionally charged. Right? So, we should never, as professionals, get under the skin of our client. That's why David Panic says, plead, that's all. Don't judge. Leave the result to the judge. Sometimes you get, and also there is one more thing. We are talking about getting justice. Let me tell you another anecdote. Have you heard about a judge called Learned Hand? See, Learned Hand was the 7th Circuit judge in America 100 years ago. They say he was the best Supreme Court judge that never was, because he was not taken to Supreme Court. But Supreme Court never interfered with the judgments. That has the deference he enjoyed or the prestige. And he is the most quoted judge of America. Not the Supreme Court judges there, but this man along with Richard Posner. These are the 2 people, both are circuit judges. Circuit means are like our High Court. So they are the ones. When he was a law clerk in Supreme Court, Oliver Wendell Holmes Jr. was a judge. He became a judge at 62, retired at 82 after his participating in World War. One day he was going by car. Oliver Wendell Holmes the Jr., he was going by car. This young learned hand, a clerk, later it became a legend though, he was waiting, so he requested, dear Justice, will you drop me at so-and-so place? Then he agreed. He got into the car. When his place came, he dropped, got out and waved the hand to the judge and said, dear Justice, please do justice. By the time...
One moment.
By the time Oliver Wendell Holmes went a few paces ahead, he backed up his car and came back. Young man, what did you say? This man was flabbergasted. Sir, I didn't tell anything wrong. I simply said, justice, please do justice. He said, that's not my duty. He said, dispensing whatever according to law is my duty. That's what he said. Why I said this, justice is a mythical term, right? What they say, music to yours is vulgar to my ears, right? What is justified for you may not be justified for me. In a spectrum where you stand, that color alone you can see. So it's a mythical term. What the virtue of common law is consistency. Under given identical circumstances, the decision making must be similar. So courts always look at the consistency rather than the correctness, because correctness is a subjective thing. So how could we say that my client hasn't got the justice or he has got it? The only question is whether under similar circumstances somebody has got it and you have been deprived. So better not focus on the outcome, plead to the best ability and leave the rest. Our client getting the justice in the sense is entirely on a different footing, which is beyond our ken or our ability to control. What cannot be done must be endured. Yes.
Any more questions, please, finally?
So there are a lot of, I've seen
Yeah.
some briefs where we see a lot of questions of law.
Remove that.
Yeah.
Once you're preparing your pleadings, there'll be 10 questions of law for us. But how do we redesign it, or what we can do to make it the best suitable for judges?
Right. Good thing. If you read the framing of issues or questions, we always say whether the Honorable High Court is right in accepting an unregistered document, blah blah, whether so and so, so and so. There are two problems. When you begin with whether is not an interrogatory word, so you cannot put a question mark at the end. It's only a sentence fragment. With great respect, though there's the practice in India and in other jurisdictions I've seen, you should never frame an issue with whether, because it's only a truncated sentence without carrying much meaning. Instead, put direct questions. I said whether the High Court is right. Is the High Court right? Right? And also we suffer from another notion that each issue must contain only one sentence. No. It's called deep issue analysis or Garnerian issue. That's Brian A. Garner is a sort of a guru of legal pleadings in the world. He is the executive or chief editor of Black's Law Dictionary. He has written a dozen books on drafting styles, especially lawyers should have. He has got a manual called Red Book of Legal Manual or Style Manual. Then he has got Modern Legal Usage. That's one book young lawyers can possess. It gives every word and how to use it, where to express and everything, it gives that one. Then he has written another book, The Winning Brief, how to plead so that you can impress the judge. And also he has written another book, The Winning Presentation, about the oral arguments. He has co-authored that with Antonin Scalia, the American Supreme Court judge who died a couple of years ago. There is another book he has again written that's about plain language for lawyers. All these books are there. They are available for a very reasonable price. And there is another book he has co-authored with 12 appellate judges. That's the Doctrine of Precedent. Right? So there he has pioneered one technique of framing issues. He said the rule is issue should not cross 75 words and it should contain minimum 2 to 3 sentences. First 2 statements leading to the question and the last one question. If you have a rambling long sentence as one unit giving the question in a statement form, it doesn't get into the mind. The questions always get into the mind, not a statement. And also let me tell you here, taking advantage of this one, human evolution always makes us, our mind, remember action rather than static things. Somebody stands over there when you are passing, you don't notice. But somebody comes across you running, you will remember. Because primordially when it comes to people for survival, a caveman perhaps going for hunt for his game, he would be afraid that some predator may attack him. So he is always afraid of movement. And the brain always remembers things which are moving. Verbs move, not the nouns. Right? Verbs move, not the nouns. For example, he has been appointed. He has got the appointment. Appointment is a static thing. But appointed is a verb that moves, visualizes somebody assuming charge, becoming an employee. Action speaks. So try to use as many verbs as possible rather than nouns. And we are very fond of nouns. They are called by grammarians zombie nouns or nominalization, where every verb is trapped into a noun when it's struggling to come out and show its action. That's why when it comes to issues, they are very vital. So statement rather than a single sentence rambling, lead the judge to the point and put the question in the end. That's more rhetorical. Rhetoric has assumed these days a bad name. Rhetoric is nothing but the art of persuasion. And the persuasion, what impresses you maybe impresses the judge. Don't think that they are different in their thinking. Yes, please.
Sir, this has been a raging debate because some people tend to use a lot of flowery language or a lot of legal language or some highly complicated words. And most of them prefer to use simple languages. So which one do you think is better, a simple draft or something which has which is flowery or which has complicated words or something which it is ordinary people like us can't understand?
Basically vocabs.
Yes, I will tell. Please. I am very fond of stories. You have to forgive me for my incorrigible habit of storytelling. I'll tell again another story for this one. And you have read that when you are very young, that is, once a mother with a child went over to Ramakrishna Paramahamsa. She said, Guruji, my son is very fond of sweets. Please tell him not to eat. His health will be spoiled. He's getting spoiled. Then he said, okay, Amma, please come next week. She came next week. Again he asked her next week. It went on for a couple of months. The mother got exasperated. And she said, what is this, Swamiji? A kid, please advise him. He loves you. He will listen. Amma, that's my weakness too. I have to curb that before I could tell. And you are asking, have you read my judgments? You would be saying you are guilty of that one. How could you give me a piece of advice? When I was on a division bench, my senior judge told me, brother, write for laymen, not for professors. But later I believed that I came down and I toned down my rhetoric, etc. But still, please remember, with all experience I'm telling, the simpler, the better, and let it be conversational. It's no sin. I say legal reading need not be lethal reading. Right? It should give immense pleasure. It should speak from the page. Enjoy that one. I suffer from a notion that it is legal, it should be really exceptional. No, that isn't. When I was practicing in Tirupati, a professor from university came with a notice and said, sir, I couldn't understand, please give a reply. I said, if you could understand, how could I make a living? Right? But those days are gone. Right? The simpler, the better. We don't have that patience. We, in the sense, the people around, they don't have the patience of going to dictionaries or, they say that there is one guy called Malinkoff, David Malinkoff. He writes a book, Legal Writing, Sense and Nonsense. In that one he says, when a judge reads your brief, he should understand or he should realize that your client has a strong case rather than a clever advocate. Right. Yes, please.
Yeah, any
Sir,
more?
this is my simple.
Yeah, please.
If ever this system of we are today dealing will be replaced by the Indian system, ever.
Yes, sir.
Simple, to the point. No appeal. तीन appeal, दो appeal या one.
Yes, sir. I agree, sir. Sir, when I was in Bombay, I wrote a judgment. And there I expressed my anguish. Then we take moral stand. I justified though, not now. I said, we adopted CPC from the English. And they abandoned that process long back. And now we could teach them a lesson or two in how to drag proceedings. And here in trial courts especially, advocates are engaged not for their advocacy skills of winning or losing, but for their skills of dragging proceedings. I have seen in Hyderabad some advocates every day filing a dozen interlocutory applications. In Bombay on the original side I have seen 10 years, 15 years, still at the interlocutory stage, even not going to the framing of issues. Yes, it's a sad state of affairs. Maybe, sir, but the problem is this. You have seen every time, 1976, there was an effort to reform. that hasn't yielded much result. 2001, again there was 3 months, I also was there in Tirupati practicing at that time. 3 months we did not go to the court saying that this pleading should not be there. Because we always believed that if the whole process is short-circuited, things happen very fast and cases are disposed of, we don't get the briefs. But remember, the faster it happens, the more people come. Now people are going to kangaroo courts to get an eviction. Right? It's counterproductive. The faster things happen, the more faith and the more money for the advocates too. Yes, sir.
Yeah.
It is to change, but who could?
Thank you.
Any more questions finally? So before asking vote of thanks to Geeta Verma, so we want to hear some horses now, some few interesting hobbies you have, sir. Very fantastic. Please, sir, you share with us hobbies and all for radio and other things. Very interesting, please, I mean.
Interesting in the sense, should I tell about my educational background?
Yeah, please, sir. You feel it.
It's not
nothing. No, you feel it, sir. I mean,
Sir, you are a practical judge. Bookish knowledge is no knowledge.
Yes. I
Please,
had
sir,
never,
that could-
I had never been,
One second.
I had never been to college. I had all my education through Open University.
This is why you are open judge.
One
Yes,
second, sir. One
through
second.
Open University.
Last minute.
Then I really wanted to learn something. So at 30, when I was a bank employee, for increment's sake, I did my Open University BA. There afterwards, when I was going to bank, a friend of mine, childhood friend, came across. He said he's a lecturer in law college. Until then, I didn't know that there was a law college in Tirupati. I said, he said, pay 15,000 rupees, you'll get a degree. So I paid 15,000 rupees taking loan from the bank. Somebody filed a bill and said that these people did not write law set, let it be cancelled. It was cancelled. The management refused to give it back. So I wrote my law set for my 15,000 rupees sake. Then even in college, I did my law. Then I felt, why not resign and practice? Then I resigned and practiced. But as I didn't go to college, but I had my high school only in Telugu medium, my mother tongue, I wanted to learn some English so that I could have my living out of it. So then I did one thing. I started listening to radio. And every day I was listening non-stop because you know what happens? If you are in Delhi, if you speak Hindi, you speak the Delhi way. If you are in Hyderabad, it's Urdu and Hindi mixed, you speak that way. If you must have seen a very popular movie called Pushpa. It's been dubbed into all languages. It was made in our area called the district where I live, Chittoor. That's been made with all the slangs, etc. So what happened? So language is a matter of imitation. And if you have a lecturer, you model yourself of your lecturer. If you have an elder brother, you model yourself of your brother. And somebody around, your colleague, you model after. I didn't have anybody there to model myself after. So I started listening to radios. Then I gathered all sorts of radios. I did all sorts of experiments. Then I felt that when you stand on your feet and you argue, sometimes you get tongue-tied. You couldn't deliver because you struggle to get words to your mouth. So I thought I should learn and have the vocabulary. Then I started learning the words as well. Then I'll tell you a simple example. Just what my advice is always to young lawyers. See, our what you call building blocks of the trade of an advocate is words. We are wordsmiths. We deal in words. The way you express, it offends, it pleases, it convinces, everything through words. Then why not we have some good command over the words? The technique of this vocabulary, having a mass of it, the way you would like to express is this. See, English language, 80% is a borrowed language, either Latin or Greek, etc. And the felicity or facility with that language is they have got roots. Once you know, you have got smartphone, please download a smart dictionary. For example, Merriam-Webster's dictionary or Oxford dictionary, whatever, they are freely available, some are for payment. There, if you look at the word, right, for example, ambulance or somnambulism, you look at this word, it's a mouthful of a word, you may not remember that one. Words are like people. They are born, they grow, they change colors, and they die. For example, idiot. Idiot is a word once which was employed for a man who did not have government job, who was not in royal service. Later it became a negative word. Nice is a positive word now. Nice once means a cheat. So words change their characters and everything. So that's why words have history. Something like you go across a person and you don't remember them next day, but he says hello to you. Type 5% your memory increased of that person. He says I am from, say, Hyderabad, it increased by 10%. He says that I am a lawyer, it increased by something. The more you know of a person, the more you remember. So are the words. For example, I'll tell you, salt is a Latin root for jump. If you know this salt as meaning jump, insult, you are jumping into somebody with your words. Consult, jumping together with your ideas, because con means companion. Com means together, panos means bread. Your companion is one who shares the bread with you. Result, something jumping back at you. Re means back, salt means jumping. Assault, ad means towards, address. Assault means jumping towards somebody. Somersault, soma means body, somnambulism. Right? Soma means body. Somersault means jumping with your body. So that way each word has a meaning. That's why we were discussing in the afternoon. That's why Seshagiri Rao ji has said, I used to just give fun to my friends saying that you ask me a word, if I don't tell a word meaning, I'll give you 10 rupees. That means I don't mind losing 10 rupees if I don't know the meaning of it. I would like to learn words because that's our trade. So my hobby is that collecting dictionaries and trying to read them, and also listening to radio so that I can improve my communication skills. It's an ongoing process. I always tell young lawyers that if you have a very clear sky at night and somebody tells each star and it's night and it doesn't become break into day, how much time will it take?
So it's a continuous process.
Continuous process. Please remember, this is called the power of incremental learning. It takes only 3.5 years, a mathematician has calculated, theoretically though. That's why most humongous tasks, very big tasks at the first blush appear to be impossible. But take 5 minutes a day, learn a few words. Take 10 minutes a day, hone some other skill. Right? That way, within no time, you'll be proficient. What's the expertise? Repeating things. Repeat whatever you love. Always, every day, learn some soft skill. It could be talking, it could be writing, it could be debating, whatever. Yes, please.
X is derived from X, 2X. This is text.
Thank you very much, sir. We all of us give a standing ovation to sir.
That's great.
Thank you, sir.
Cover.
Thank you, sir. I feel honored. Really.
Yes.
Senior Advocate Dama Seshadri Naidu, in addition to his lecture, has also circulated the art of legal drafting and pleadings for the benefit of young bar, which is a great tool and I have the honor to present today. This is a tool and astronomically help us to master the art of legal drafting, to stay wary of prolixity and stay on the point with precision. Let's understand the art of legal drafting pleadings with prolixity and precision. We shall start by taking a look at the case of Gaurang Mangesh versus Sonia Gaurang, argued before the Honorable High Court of Bombay at Goa on 20th July 2020. The High Court of Bombay, at per single judge, has lamented at the lack of precision and the prolixity of the pleadings. Thus, the facts fit into a paragraph and the issue into a single sentence, but the pleadings run into pages. The petitioner's writ pleadings cover 100 pages and the petitioner's reply to match over 50 pages. Two seasoned senior counsel argued the matter. To that extent, the court derived admirable assistance. No doubt, but the pleadings, I must say, are painfully prolix. I do not wish to sound harsh by singling out this case. It is rather a general malady that afflicts our profession. Multiplied pages do not signify precision or perfection, not even anticipation, but beauty lies in brevity, even in law. Prolixity and complexity go hand in hand, the legal profession being no exception, but it compels the court, like a domino effect, to ramble on in its judgment, lest the court faces the allegation it has given short shrift to a lawyer's labor. You speak like a lawyer is a compliment. You write like a lawyer is not, I reckon. The drafter's want in writing skill may lead to the court judging ill. Let me conclude by invoking Alexander Pope. Words are like leaves, and where they most abound, much fruit of sense beneath is rarely found. Let us understand by questioning ourselves. Why is writing with precision is important, if at all, law, language and litigation. Let us discuss the role of stay and innocuous comma in interpreting the law or context. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. You know, leaves literally hang on a comma. That comma in the Second Amendment of the Bill of the Rights ratified 15th of December 1791 is a pivot point on which ideological wars have been waged and the lives hang in the balance. Taking the Canadian example, this agreement shall be effective from the date it is made and shall continue in force for a period of 5 years. From the date it is made and thereafter for successive 5 years terms, unless and until terminated by 1 year prior notice in writing by either party. Next, we have to look at the American example. Definition of gasoline, naphtha, and the other liquid motor fuels or any device or substitute, therefore, commonly used in internal combustion engine. If you notice, original version does not have that comma. Another American experience. Fruits, plants, tropical and semi-tropical for the purpose of propagation or cultivation. If you see the modified version, fruit, plants tropical and semi-tropical for the purpose of propagation or cultivation. In all the above case, a misplaced comma has played a havoc with the real intent of the provision, statutory or contractual. Let us jump to our own problem. 233 appointments of district judges. First, appointment of person to be and the posting and promotion of district judges in any state shall be made by the governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. Second, a person not already in the service of the union or of the state shall only be eligible to be appointed a district judge if he has been or not less than 7 years an advocate or a pleader and is recommended by the High Court for appointment. The question is, should the advocate be continuing as an advocate on the date of his applying? Or is it sufficient that he has completed 7 years as an advocate any time before he is applying for the post? Article 42 of Constitution, the law declared by the Supreme Court shall be binding on all courts within the territory of India. On all courts? Does this include Supreme Court also? For there is no exclusionary other after all. One final salvo. Lockhart versus United States 2016. An accused possessing child pornography on conviction have to undergo a 10-year mandatory minimum sentence. But the sentence increases to life if the accused has a prior conviction so and so. Under the laws of any state relating to aggravated sexual abuse or abusive sexual conduct involving a minor or war. The rule of last antecedent, Justice Sotomayor wrote the majority judgment wherein Justice Elena Kagan wrote the minority judgment. The problem with an invisible speaker, that is the writer. We wanted to stay until Sandeep arrived. We wanted to stay until Sandeep arrived. If you notice, the first sentence means we wanted to stay until Sandeep has arrived because we like him or we have some work with him. The second sentence means we want to leave as soon as he arrives because we cannot bear him. Isn't it funny? Now let us understand with second example. They left thankfully. They left thankfully. The first means they left happily. In the second, it means we are happy because they left. Third example. Yesterday the entry was free for children who studied in our school. That means there are many children, but entry is free for the children from our school. If you notice, yesterday the entry was free for children who study in our school. This sentence means the entry is free for all the children because they are all from our school. Now next, moving to the mechanism. Brass tracks explain who, what, when, where, why, how. Too often, lawyers jump right into the legal nuisance of the case without explaining in clear terms the legal context in which the case arises. The deeper you are into your litigation, the easier it is to forget what Chief Justice Abrahamson calls the context in the case arises. Second, the short list. Kindly see. Number your path to victory. The top advocates love numbered list, list in the facts, list in the arguments, and most of all, list in the introduction. Nothing helps us a brief whole together better than a list of legal, factual, or common sense reason that you should prevail. For example, first one, the equities strongly favor the petitioner because. Second, on the other hand, the petitioner will suffer irreparable harm if so and so. Third, besides the public interest too favors the petitioners because so and so. Let's point on the hand. You need to address threshold because before addressing the merits, for example, plaintiff lacks standing to raise his claims for relief before this honorable court because. But even if plaintiff could satisfy the justiciability requirements, this case needs to be rejected for another reason so and so. Next point up, your dispute is complex or fact driven. For example, first, this case does not concern any title dispute, which is conflict with the second one. If you see, the policy the government has adopted throws cloud over the petitioner's title. Thus, it collaterally affects the petitioner title. Wherein third point contrasts. The policy strictly violates the constitutional mandate. In fourth point, we see juxtaposition. The petitioner by no means is seeking any relief which any inferior forum could grant. On the contrary, he stands before the apex court to vindicate his fundamental rights. Next is, you need to regain the offensive response to your opponent's argument. The petitioner's plea does not adequately address any of the fundamental and fatal flaws in this case. First, the information of the defendant allegedly disclosed was either previously disclosed to the public by the petitioner himself or is not something unknown to the public until then. Second, the petitioner has conveniently ignored his admission earlier before the statutory authorities. Third, the respondent has always enjoyed the statutory protection because of the public interest element his disclosure has achieved. Give the court a reason to want to find for you, or else it should ask, why should I care? The fear of misconstructing or a doctrine or a statute, the fear of creating new duties, rule or defenses, the fear of reaching an unfair result or causing harm. Judges are curious about the social reality. They want their lawyers to help them dig below the semantic surface. You can always invoke the judge's primal fear, the fear of getting law wrong. For example, the petitioner respectfully submits that anything less than reversal of the impugned judgment would send a highly visible, detrimental signal that this court has retreated from its clear ruling in so versus so. Pleadings of Barack Obama. The lower court's holding fundamentally misreads this court's voting rights jurisprudence as well as that of other circuits. Moreover, this holding turns the Voting Rights Act on its head by immunizing intentional racial discrimination as long as the bottom line of a single member district redistricting plan is proportionality. Don't be fooled. Draw a line in the sand. Many legal disputes boil down to a clash between two competing views. By contrasting those two views in your introduction, you can preempt your opponent attempts to make the case into something it's not. For example, the issue in this case is not whether the Constitution compels the university to adopt a special admission program for minorities, but only whether the Constitution permits the university to pursue that course. For example, the Information Technology Act is a regulatory law intended to help protect the public from future harm by collecting truthful information and making it available to those who choose to access. It is not a penal law intended to punish people past acts. For example, Mary Jo White, Trump versus Aubrey. This lawsuit never has been about recovering damages that Trump allegedly sustained as a result of the book, but instead is about to Trump attempting to exact revenge against Aubrey for writing that Trump perceived as a negative book about him out and to deter other journalists from doing the same. Next important point, tell the tale. Imagine you're telling a story, rather you're selling a story. For example, there are three important issues in this case. The first issue is whether so and so. Next highlight, panoramic shot. Set the stage and sound your theme. For example, this case involves the material misstatement of Sunbeam Corporation's financial condition during the years 1996 to 1998. For example, the self-financing universities have long enjoyed autonomy over their admissions policies and procedures. Not that is threatened. In their journey from the assembly line to the dealer's showroom, automobiles occasionally experience minor damaging requiring repair or refurnishing, but they do not require wholesale replacement. Next example, Caterpillar, Fifth Avenue Church versus City of New York. As part of its Christian mission to care for the poor, the church has for many years ministered to the homeless by providing limited sanctuary. This case arises from the city's effort to disrupt this religious practice. Next, show, not tell. Let's choice details speak for themselves. Next, once upon a time. Replace date with phrases that convey a sense of time. Take the example of service dispute. Headlines. Use headline to break up your fact section and to add persuasive effect. Next is back to life. Center technical matter on people or entities. Fewer than 27 average words per sentence. Less than 20% of your sentences may be passive. Another trend to set. Poker face. Concede bad facts but put them in context. That is, take away the sting. Spend time amazing. That in a compelling way for your side, but do not omit the ones that go the other way. Tackle these uncooperative facts but put them in perspective. Next is end with a bang. Leave the quote with a final image or thought. Sneak preview. Include an umbrella paragraph before your heading and subheading. Wish I were there. Start each paragraph by answering a question you expect the quote to have. Long in the tooth, say, me too. One of the most persuasive points you can make, of course, is that quotes have long done what you want or have never done what your opponents want. Peas in a pod. Link your party with the party in the cited case. For example, in So versus So, the petitioner faced a similar dilemma. He argued that so and so, and this honorable court has accepted that contention. In So versus So, the defendant bank, like respondent here, has contended that in contrast, the debtor, like the petitioner here, has submitted that, and this honorable court has accepted the debtor's contention. Here the respondent has engaged precisely in the type of conduct described in So versus So. He told investors he would purchase and sell securities, but he never did. Minds their words. Much pithy quoted phrase into a sentence about your own case. One upon claim that case you're citing applies even more to your own dispute. The principle of laid down in So versus So applies to the facts of this case even with greater force. Interception. Claim that a case your opponent cites help you along. One fell swoop. Distinguish a line of cases all at once. Speak to yourselves. Include a single sentence quotation. Whenever you use block quotation, you have to give the summary of the quotation either before the quotation begins or after. Sneak through justice, so and so. This court affirmed that the owner's liability for the officer's wanton acts did not extend to punitive damages in So versus So. Proceeding further, the power of plain language. Winston Churchill, a full-time politician, has won a Nobel. It was not for his political achievement, it was for his literary works. Blood, toil, sweat and tears, and of victory at all cost. Victory in spite of all terror, victory however long and hard the road may be. Now let us understand the mechanics of good legal writing. First, avoid surplus word. The genesis of the dispute between the parties was an agreement. Let us understand with this example. The dispute began with an agreement. Feeling aggrieved and dissatisfied with the impugned judgment rendered by the trial court, aggrieved, the appellant assails the trial court's judgment dated so and so. Let us elaborate the version, and second is concisive version. Avoid compound proposition. For example, instead of at the point in time, then, replace by means of by reason of, by, replace by virtue of, because of, or by or under. For the purpose of this, use to. For the reason that, because. From the point of view, from or for. In accordance with, by or under. In accordance with, again by, under. In as much, since. In connection with, by or under. In order to, in the event that, if. Prior to, before. Subsequent to, after. Trim out verbose words cluster. Example, he was aware of the fact that. Instead you can use he knew that. Despite the fact that. Use although, even though. Because of the fact, because. As to the case cited, that was an instance in which, in that case. Let us look at plain language alternatives. Accede to, agree to, adequate enough, enough, adjacent to, next to, adversely impact on, affect, afford an opportunity, allow or let. As a consequence of, because. Next topic to understand is zombie nouns. Helen Sword makes an observation that nominalization decreases clarity. This sentence includes 9 words. Now, in a better way, we can say Helen Sword observed that nominalization decreases clarity. Herein, 7 words. Paul present a summary of justification by faith. This sentence includes 8 words. Now you can better it. Paul summarizes justification by faith. This sentence includes just the 5 words. John places an emphasis on faith. 6 words. Better version is John emphasized faith. Just the 3 words.
Wait for her. She will give vote of thanks, but please. Yeah, cover this, please.
Sir,
No, not this.
Honorable Justice, you not only take our heart and mind, I believe our all 5 senses, that is our nose, our eyes, our skin, that all were connected with your speech and the words, the way you depicted the words. So I'm grateful. We all are grateful.